The first thing that you want to do is you want to take a look at your corporate formation documents, either the type of partnership that you are, a corporation or an LLC, a limited liability company, and see what the documents say with regard to termination of the relationship. If the documents contain, and these types of documents can be a buyer-sell agreement, a confidentiality agreement, it could be a shareholders agreement, employment agreements, a whole list of agreements that you and your partner may have entered into during the course of the life of the company. At that point in time, we look into those documents and we say, all right, what do they provide when one partner, one member, and I'll use the term interchangeably here, wants to leave, either by voluntary or involuntary. And that becomes the key. So the key first step is, what do my documents say with regard to when I started this company? The next question that you have to ask, and this is always going to lead from question to question, is it a voluntary dissolution? Is it a voluntary arrangement? Are you on friendly terms and that both of you agree that we want to split? If that's the case, then it becomes a lot more simpler than it does if it's a disagreement. And the first thing that you want to do with that is, and there's different ways that it can be done, is that you can either divide the company voluntarily by saying, I accept certain assets, you accept certain assets, we pay off all the debts, and at that point in time, we hopefully have a large sum of money left over after everybody's walked away. If both parties are going to dissolve, then that's the way to do it. You get an evaluation of the company and you agree to split up the assets or sell the assets, pay off your debts, and then walk away. If, however, one member wants to stay and one member wants to leave, then it becomes a little more difficult because at that point in time you have to negotiate the exit plan. And one of the factors that come into agreement after you've looked at your documents, and if the documents control how it's to be done, then you follow that. But if there is no document in place, then you enter into basically a series of negotiations with your exiting member to say, okay, I think the company is worth XYZ, and your percentage of it is, say, 45%. At that point in time, we then arrange to see how we're going to evaluate the full company value, and then arrange to see how your 45% is going to be paid. At that point in time, the difficulty from the exiting member's point of view is, am I going to get paid? How am I going to get paid? And on what terms am I going to get paid, either over cash in a lump sum, or is it going to get paid in a payout? And at that point in time, you have to evaluate the values and then arrive at what they are, as well as the liabilities. And then you end up with a net equity, and then you apply the 45% to allow the value to be determined. This can be either done by an appraisal, it can be done by an agreement of the parties where they say, okay, we think the company is worth XYZ, and we agree on that number, and then move forward onto that. From the exiting partner's point of view, it's how am I going to get my money, and how am I going to get paid, and on what terms over time am I getting paid, and what security do I have if I don't get paid? And that is, do I get my company back because you didn't pay me, or do I have some other remedy to get to my money? From the member who is staying in the company, his problems or his concerns are, how do I pay my exiting partner? Do I pay him out of my corporate funds? Do I then go to the bank and borrow against that? Do I pay him on a monthly basis on a payout, or can I afford to lump sum it? The concern will be from the exiting partner is, I want my money now and I want my money as soon as I can. From the company's point of view, and the remaining partner is, can I afford to pay him based out of what I have left after he leaves? And so you have that negotiation take place. If at some point in time that is agreed upon, then it's very simple. You enter into an agreement that says, this is how I'm going to do it. I'm going to give you my shares, I'm going to give you my membership in exchange for a payment. It's incorporated into an agreement. That agreement from the exiting partner's side is my security, my payment terms, and what can I do after I leave the company. From the remaining member's point of view, his thought process and his concern is, How do I make sure that I afford it, pay it, and I got to make sure that Joe, my exiting partner, doesn't open up across the street and start competing against me because he's changed his mind the minute that he walks out of the company that I now have. And the way we do that is with certain covenants with regard to his ability to compete, his ability to keep customer list. We keep the customer list private, and the trade secrets of the company. We would incorporate that into the exit agreement. And at that point in time, that exiting member can no longer compete for a reasonable period of time in that business or for a reasonable distance from my business. And at that point, once you've got that into an agreement, then you're pretty much set. Now, the second step is, what if this is involuntary? And one guy wants to leave, but the other guy says, I don't want to leave. The key questions there then are, come back to your documents. How do I get a withdrawal of a partner, either by forcing him out, or is there an option in the agreement that if one of us decides that we want out, then we can buy the other fellow out under those terms? If you don't have an agreement, it then becomes more of a corporate struggle. The corporate struggle then revolves around who controls the company. Do I, as the guy who wants my exiting partner to go on, control 51% of either the voting stock in the corporation, the membership interest, the partnership interest, whatever it is, and do I then have the ability to do certain things within those documents? Your caveat or your concern is that you, as the member who wants to force your partner out, must act with a duty of loyalty to him and a duty in the best interest of the company. If you do that, then you may be in violation of that and be responsible for certain damages if you force him out unlawfully or against the terms of your agreements. Once you determine that you're in control, then what you can do is certain political things, if for lack of a better term, and that is you can increase your own salary, you can increase the shares of stock that you own, you can decrease his salary, you can take away some of his goodies, his car, his life insurance provisions, and things like that, that are kind of paid for by the company, but would no longer be paid for the company because you're not going to give him a benefit. The concern at that point is then you've put him in a situation where he doesn't really want to stay. Now, that's all based upon your control. If you don't have that control, or it's a 50-50 proposition, you're in a much more difficult situation. And that is, I can't force him to lower his salary. I can't control the company to increase my salary. I can't add more shares. So then I have to resort to almost to litigation at that point if he's not going to voluntarily do it. And at that point, you then must go to court and get into a shareholders' dispute over control. That is the least of your options because that becomes extremely expensive and is not of any benefit because you're paying the lawyers and not paying yourselves. So we would at that point try to avoid the last event of litigation. If, however, you're the minority member, at that point in time you can, if the majority member is imposing certain restrictions on you, you can go to court and sue him for oppression, breach of his duty of his fiduciary duty and or his duty of loyalty. And at that point in time, you then are trying to force him to give you a higher price. The bottom line with regard to the involuntary dissolution is if somebody had one partner or one member has expressed the interest no longer to be partners with the other one, it's kind of like a divorce. If one says I want out, then you really shouldn't be fighting over it, and you should try to reduce your expenses and reach an amicable agreement, which is in the best interest of all the parties, to get the assets secured, the liabilities paid off, and you go your separate ways. And I hope that is of some help to you in resolving your differences.